Hi there, I'm Jim Zirin. Welcome back to more Conversations in the Digital Age. True justice is always an aspiration, but unfortunately, all too often, jury verdicts and court judgments produce disturbing, unanswered questions. With us is super lawyer Joel Cohen, a criminal defense lawyer and a former prosecutor. Joel has written an important book entitled Broken Scales, in which he reflects on some recent outcomes in our justice system. The story is seen sometimes through the eyes of a prosecutor, sometimes a judge, sometimes a defendant, and even a holdout juror. Broken Scales had me riveted. Each of the book's 10 highly readable vignettes consists of a background narrative followed by a verbatim transcript of a recorded interview Joel conducted with someone in a position to reveal a shocking example of a justice system possibly gone wrong. Joel Cohen, we're delighted to welcome you to the program.
Thank you so much for having me.
Now, Joel, justice is always an aspiration. Injustice should be infrequent or non-existent, but you point to some shocking examples, more numerous than is comfortable. How did you find these cases, and why did you decide to write this book?
Well, I had previously written a book about judging and how judges decide cases, things that you would not know about, even if you were a lawyer, even if you were a judge. What's going on inside a judge's mind when he's or she is deciding a case that might not be in the court papers or in the record? And then I thought, well, what about the people who are the victims of injustice in one way or another, or other people who are participants in justice, and what's going on in their mind? How have their lives been affected in any way by virtue of their role in an injustice or what might be perceived by the country as an injustice?
Now, why did you choose the format of a narrative followed by, in effect, a transcript of an interview? Perhaps as a lawyer you're used to transcripts, but as opposed to just a narrative of the various cases?
Well, one of the reasons I thought was because frequently when we read a story by a writer about a particular event in life, you basically get the prejudices of the writer himself or herself there. I thought the better idea in terms of talking to people involved in injustices is to find out what they have to say, and my job was just to ask the right questions, hopefully, that draws them out on things that they have thought about in their lives and maybe they haven't even thought about, but hear it for the first time from them live, and that's why I chose to do it that way.
Now, a number of these cases are quite well known. For example, Tawana Brawley and Eton Pates, but the majority of them are cases less well known. How did you find these cases?
It was sort of interesting. I worked with my colleague Dale Degenshine, who made a major contribution to this book in terms of the introductions that you're talking about. But basically, sometimes you would just see something in a newspaper, or you would come across it by reading some article that you thought would never lead in that direction. Sometimes, frankly, some of these stories have been aired on national programs like 60 Minutes. But obviously, they're looking at a television audience. It's a different type of discussion, and I wanted to interview those people for myself to find out what they had to say in the context of which I was asking it.
And you would think at first blush that all these cases would involve someone who was wrongfully convicted and perhaps later exonerated. You have some instances of that, but you have different kinds of alleged injustices, if you will. As well. For example, the chief judge in Iowa who was recalled because she wrote an opinion authorizing gay marriage long before the Supreme Court did.
Yeah, it's an extraordinary case. So the chief justice and two other judges on the Iowa Supreme Court were coming up for recall vote. It's kind of a standard vote every couple of years when you're on the Supreme Court, and you don't think much of it. They knew, however, those three judges, they were coming up for that periodic vote by the electorate, and they knew going in that same-sex marriage in Iowa would not be particularly popular, but they decided we have to vote our conscience on what the issue is. A lot of out-of-state sort of evangelical money, far-right money was coming into the election campaign. They basically got voted out of office, the three of them, including the Chief Justice of the state, as a result of voting their conscience in terms of where they came out on same-sex marriage.
Well,
not
only their conscience, but it was their interpretation of the state constitution.
Correct, absolutely correct.
Now, you move along to a case that every New Yorker will always remember. It's the chilling saga of Etan Pates, who disappeared in '79. He was a 6-year-old child. His picture was on milk cartons. And it wasn't until 33 years later, in 2012, that Pedro Hernandez fell under the suspicion of the district attorney's office as a suspect in the case. Tell the story of how that happened.
The guy confessed to different groups. He confessed to a church group. He confessed to his family and whatnot. Ultimately, he gets prosecuted for this crime that's gone unsolved for so many years. And as you say, people in New York all knew about that crime. They were 30 years younger in their lives when it happened. And he gets prosecuted by the district attorney in New York County, armed with those confessions and the horrible publicity about the case. It's hard for his lawyer to think he could possibly gain an acquittal in the case, but there was one juror. He was sort of like the one holdout in 12 Angry Men, and he stood up for an acquittal in that case for a long period of time against a very, very oppositional jury in that case. He also, afterwards, I interviewed him before the second trial. There was a hung jury in that case, 11-1. There was a second trial where the jurors from the first trial would come in support of the prosecution at the second trial, and he came in support of the defendant in the second trial. So the question is, if there is an injustice in that case, is the injustice because one man in opposition to 23 jurors in 2 different cases held out for an acquittal? Maybe Hernandez should have been convicted in the first case. Maybe that's the injustice. Not so clear in that case whether that situation is injustice. But this guy, Adam Serwa, who was interviewed and has been interviewed a lot, he sort of has made a point of being interviewed about the case based on his views, whether the injustice is because of him or despite him.
Well, it was a weak case for the prosecution in many respects, wasn't it? Because they never found the body, and there was no physical evidence connecting Hernandez to the case, and Hernandez, for 33 years, had a totally clean record, and the prosecution rested on his confession. Now, confessions are supposed to be preeminent evidence of guilt, but they can also be very misleading, can't they?
For sure, and that happens all the time. It's incredible the work that Barry Scheck and the Innocence Project have done with that kind of thing. So many cases where there are false confessions, and then these folks are exonerated by DNA or other evidence.
Now, in the Pates case particularly, there was someone else who was suspected of committing the crime. Why don't you tell about that?
Well, there was another person who had basically been under investigation for a long period of time. A former prosecutor in the Southern District concluded that he was actually the defendant. As my understanding, that former assistant U.S. attorney testified in the first trial to basically say there's an alternative theory of the case, that this other guy is in fact guilty. I'm told he didn't testify in the second case, which is kind of interesting. Apparently the defense didn't think he would be such a valuable witness in that case, but that's the best way to defend a case, to have an alternative theory of the case. In fact, another guy who's under tremendous suspicion for having been, in fact, the offender.
Well, there was no evidence whatsoever that Hernandez, although he worked close to where the Pates family lived, even knew Etan Pates, while this other individual, Jose Ramos, was a convicted pedophile. He was a friend of Etan's babysitter, and he had known Etan Pates. He admitted he'd known him. And he said he'd been with a boy he was 90% sure was Etan on the day of the murder. Now, doesn't that create a reasonable doubt in your mind?
You would think, but I wasn't sitting on the jury, and neither were you. So it's kind of hard to understand how that happens.
But it did in the mind of Adam Serwa.
Certainly in the mind of
Adam Serwa. Now, he attended the second trial, didn't he?
He did.
And
religiously.
And he was a consultant to the defense in the second trial.
Yes.
And do you think he went too far as someone who'd been on a jury and was supposed to be unbiased and impartial?
Well, it's perfectly his right to do that and all that. You sort of wondered, and I sort of wondered when I was, because this interview occurred before the second trial, where that would come out and what would be my own thinking about whether there's an injustice or not. Hard to say. Hard to say, certainly hard to say for me to say whether Hernandez was guilty or not. But it's sort of interesting, 23 jurors, he was the only holdout among 2 juries.
Why did you decide to tell this story of possible injustice through the eyes of Sirwa rather than Hernandez? You didn't interview Hernandez.
I didn't interview Hernandez.
Or Ramos, you didn't interview Ramos, or Cy Vance, the district attorney, or any of the defense lawyers. I
suspect Cy Vance wouldn't have talked to me. I suspect those 2 defendants wouldn't have talked to me. And in particular, Hernandez's case, he had, by all accounts, a very low IQ. I'm not so sure he would be equipped to do it. And I thought talking to Sirwa would look at it, again, the book is to look at injustices from different perspectives. He's a totally different perspective. You generally don't look at a case through the eyes of a juror. You used to see on say, after O.J. Simpson's conviction, all the jurors would, make a play on television and say what they had to say about the case. And generally, they would say routine things like, well, we followed the jurors' instructions. We didn't think there was enough evidence under the instructions. My sense of Sirwa is he would be a little more direct in saying what was going on in the jury room.
Now, do you believe that Hernandez may have been the victim of community hysteria or desire for closure in the case of Eitan Pates, which had gone unresolved for so long?
No question. It's extremely hard to try a case in a situation where there's so much publicity and where people, like in a case like that, or the son of Sam, that never went to trial, but where there's so much hyper hysteria in a community over a crime that people can relate to. People walking down the street with their kids nowadays even think about Eitan Pates and wondering whether they can let their child walk free for a block or so. Very hard to gain an acquittal in a case like that.
Of the 10, you have 2 other cases which involve, at least 2 other cases involving community hysteria. You have the case of Mrs. Moskovitz, who was, in effect, she was convicted of being part of a spy ring. And you have the case of Ghazi after 9/11, who was an Egyptian and was arrested because he was an occupant of a hotel room near the World Trade Center. That also involved a purported confession. Why don't you tell us a little bit about the Ghazi case?
The story about Ghazi is in many respects my favorite story. Ghazi was like a 20-year-old former member of an adjunct to the Egyptian Air Force, an organization that helps prepare the Air Force. He was working in Egypt as a student, and he became an exchange student at Polytechnic Institute in New York at age 20 or 21. They put him up at the Millennium Hotel, which stands right opposite the Trade Center. So on 9/11, he's living at the hotel temporarily, and the hotel is evacuated for obvious reasons. He leaves for about 2 months, stays with some people he knows, and he gets a call to come back and pick up his belongings once the hotel is reopened. He goes to pick up his belongings, and there's a clerk who says, okay, you had a Quran. He's Egyptian, Muslim. You had a Quran, you had a prayer rug, you had some clothing. He said, check, 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 all of those. Well, you also had a transceiver device. Well, he happened to know what a transceiver device is because he had been associated with the Air Force in Egypt. And he said, I didn't have a transceiver device. Transceiver device is a device by which you could talk to a plane from the ground, vice versa. This was right opposite the World Trade Center on 9/11. He said, that's not mine. Oh yeah, it's yours. By the way, the FBI's down the hall and they want to talk to you. He goes to see the FBI and the FBI says, you had the transceiver, it was in your room, it was signed to you, and basically we're taking you into custody as a material witness. They didn't have enough to prosecute him for 9/11, but as a material witness, they thought, the FBI did, they had the 20th hijacker and literally the only one who was alive. He gets brought before Judge Rakoff in the Southern District of New York, and he's essentially told, you're going to have to be remanded without bail, given the circumstances of this crime. He says, I want to take a lie detector test. Judge Rakoff says, not so fast, that's not such a good idea. And his lawyer, who's court appointed, he doesn't know him, said, you don't want to take a lie detector test. No, I insist on taking a lie detector test. The FBI sets up a lie detector test, and his lawyer is sitting on the outside of the room, doesn't know what's going on in the room. There is generally, when a lie detector test is given, a pre-interview. The FBI agent says, let's cut the baloney. We know you're the guy. Not only do we know you're the guy, we know where your parents are in Egypt, and we're going to go after them, and we know where your brother is upstate New York, and we're going to go after him.
Well, that's clear coercion, isn't it?
Totally coercion. However, Abdullah Ghazi, who maintains his innocence, says, I'm the guy. I bought the transceiver device, or I bought it at a Radio Shack or some such place on the other side of the Brooklyn Bridge, and he admits it. The government indicts him for having made the false statement to the FBI saying
the first time around
that he's innocent, yeah, and he goes into custody. He's walking around the Metropolitan Correctional Center a few blocks away from there. He's in handcuffs all the time. He's got 5 guards around him wherever he goes, whenever he's released from solitary confinement for half an hour or so.
Maybe facing a life sentence in Guantanamo.
He's the 20th hijacker, okay? 34 days into this kind of procedure, he's told, okay, you're going to be released. He says, I know I don't have a court date today. What are you talking about? The marshal wants to see you. He goes down to the marshal's office, sits down, and they're giving him back some of his belongings. He says, what's this all about? He said, oh, didn't they tell you? An airline pilot whose transceiver device it was, a legitimate airline pilot, came forward to claim the device. You're innocent. You're free to go. Sorry, we gave you a bad month, basically.
But then there was something involving a security guard, wasn't there? He was the one who said he found the device in Higazi's safe.
He framed Higazi by saying that was in Higazi's room. He was ultimately prosecuted, got a really lenient sentence.
He lied to the FBI.
Lied to the FBI. He got a lenient sentence and ultimately was released. I asked Higazi, what would have happened to that guy, the guy who framed you in Egypt? And Ghazi, during the interview, as a total gentleman, says, I don't even want to talk about what would have happened to him in Egypt.
So it resonates in some respect with the Hernandez case
because
of the false confession. Now, you then move on to a number of cases, but one of them is that of Miriam Moskovitz, whom you met when she was almost 100 years old. Why don't you tell about that?
I did. So she's a lovely old lady. She's now 100. And we met her, Dale and I went to interview her in her home. She lives alone in New Jersey. It's extraordinary. Has her marbles completely. She's a little frail and hard to get around, but she's very strong-minded. She had a boyfriend, who was basically persuading her, she was a young woman at the time, to get involved in the Communist Party. She didn't think anything about overthrowing the country or anything like that, but getting involved in the Communist Party in the late 40s, and it was part of her relationship with him. And she joined it. And ultimately, the friend, his name was Abe Rothman, he was clearly involved in some way, not exactly clear, but he was somehow involved in active communism efforts in the United States. And he is prosecuted, but she is brought along for the ride by the prosecutors in the Southern District of New York. Roy Cohen famously prosecuted that case with his colleague as a run-up to the Rosenberg case. And she's prosecuted.
And isn't it true that Cohen thought, and then Sapol, who was also the prosecutor, thought they would do it sort of a dry run for the Rosenberg case?
A dry run for the Rosenberg.
Because the witness was Bentley, and they wanted to see how she would do on cross-examination.
Exactly right. You've carefully read the book.
Well, of course I read the book. It's terrific.
So thank you. So she gets prosecuted, and the unfortunate thing for her is she is represented by a very able lawyer, his name was Kleinman, by the same lawyer representing the friend, Abe Rothman. The result of it is, ultimately, when a lawyer represents 2 clients at the same time, he can't adequately represent the person who's the lesser light in the case. The result of it, she got convicted, along for the ride, got 2 years in jail. Her life has been a life ever since then, 65 years or so, trying to get vindicated, trying to get exonerated for a crime that she thinks that she was improperly convicted of.
Well, just pause for a moment. There was another issue in the case, wasn't there? Because she was denied access at the time of the trial to grand jury testimony and also other statements that perhaps Bentley and Gold gave to the FBI that would have exonerated her.
For sure. Nowadays, the law is that if a witness testifies in the grand jury, when he or gives interviews to the FBI, when he testifies at trial, the defendant's lawyer is entitled to the prior statements. So lawyers make a lot of hay. I've done it in my life from prior inconsistent statements by witnesses. That wasn't the law at the time, and it wasn't the law at the time, as you know, that Brady material, exculpatory material, had to be turned over to the defendant before trial. The result of which is she never learned till many years later that the main witness against her had given inconsistent exculpatory statements about her before trial. She tried as recently as 2 years to get her conviction thrown out on that basis.
2 years ago.
2 years ago, and the judge correctly decided, at least on that issue of the law, that that wasn't the law at the time of that trial, and that law wasn't, those case law wasn't applied retroactively to 1950 or so when she was prosecuted.
Well, you had the same issue in the Rosenberg case, where
sure.
Greenglass and his wife particularly had given inconsistent testimony in the grand jury, and that didn't come out until much later.
I have a wonderful anecdote about Miriam Moskovitz, who's a lovely woman. She invited Dale and myself to her 100th birthday party last summer. And she told me she was applying, President Obama was still a president, she was applying for a pardon or clemency from the president. And she said that the FBI, who had been on her case badly 50, 60, 65 years ago, came to interview her. They vet pardon applications. So they came to interview her. And I said, what were they like? She says, oh, they're very nice, not like they were back when. I said, well, did they ask you any particular questions? They asked me, what have you been doing in the last couple of years? And she said, I'm 100 years old. What do you expect I'm doing?
Moskovitz, of course, had a lot of justice. She had a trial, and she had an appeal, and she then had this collateral attack. Lawyers call it a coram nobis, yeah, for a good judge, right, Judge Hellerstein, years later, and she lost all the way down the line. So why do you consider this an instance of possible injustice? Well,
the judge, by the way, who turned her down is a good friend of mine, actually.
Mine too.
And a former law partner, Alvin Hellerstein. And the injustice, it seems to me, is somebody who may indeed have been innocent, didn't, because of how the law has evolved slowly in that direction, never got the opportunity. If that had happened today, that case would have been thrown out. If she had been tried now, the case would have been thrown out for the prosecutor not having turned over exculpatory evidence. Just wasn't the law at that time, and that's a sad fact.
Does it sometimes become too late to correct an injustice? Here the woman is 100 years old. She really just wanted somebody to say, you know, Miriam, our system did you a bad turn.
You know, you're making a good, that's the book that you should write, actually. Sometimes it turns out that it's too late to correct an injustice.
So what are your observations, Joel, on how we might change our system to get away from the types of cases you describe in your fascinating book?
Well, it's hard to say. You know, I'm a former prosecutor. You were a former prosecutor. When we're sitting in a prosecutor's office, we don't see injustices. We see our colleagues are honorable people. We think ourselves as honorable people, and that we're not doing anything to bend the law in a particular direction or bend the facts. But it happens.
Well, our job is to see that justice is done, not to convict the guilty. That's very clear in our canons. It's clear in statements of none other than Jackson when he was Attorney General.
It may have affected
Justice Jackson.
Yeah. The problem is it may have affected me and affected others. When we think that somebody is guilty, we're not particularly bothered by that. Maybe we're just cutting off the edges of justice a little bit. I had a colleague of mine who was he was like a war hero, a wonderful man and whatnot, and I once came to him with an issue as to whether I had to turn over some evidence to a defense lawyer. This is when I was a prosecutor. And he looked at the evidence. The case involved is Brady versus Maryland. That's the case that decides whether you have to turn that over. I looked at him, and his attitude was, Brady's just another Irish name. Okay, he thought justice was being done. It didn't matter whether that technical decision had applied to that case.
So unfortunately, we've come to an end, but I have a question for you, Joel Cohen. Are the scales of justice too often broken in America?
Well, that's sort of like a lob shot at me. It's too often. If one guy, you think about this, if Barry Scheck has literally taken 40 or 50 people off a death row. I mean, can you imagine one person being on death row for a crime he or she didn't commit? Extraordinary. And this happens so often. And Brady is sort of the violations of Brady by prosecutors, sometimes with bad intent, sometimes not with bad intent. It just happens too often, and something has to be done about it.
Brady is that exculpatory evidence has to be turned over to the defense.
Correct.
Joel Cohen, thank you so much for coming by. This has been just marvelous.
Great.
Thank you for coming by. Please read Broken Scales. It's a fascinating book. Tune in next week for more conversations in the digital age. I'm Jim Zirin. Take care and be well and all the best.